Welcome to the second lecture in our series on the Constitution. If you haven't already watched Part 1, I strongly recommend you do so, as it gives you the fundamentals of where the Constitution gains its legitimacy. This lecture will, in essence, be about how to read the Constitution and how to determine the correct meaning from its passages. We hear a lot of politicians and pundits talk about different parts of the Constitution and what they mean, and often they contradict each other. Even Supreme Court justices can't seem to agree. So how are we to determine what is the right reading? Currently, the two most popular ways of interpreting the Constitution are original intent, which seeks to determine the original intent of the founders, and living text, where the Constitution is a living document whose meaning changes with the times. In this lecture, I intend to show that both of these methods are fallacious, and describe the only rational way the meaning of the clauses in the Constitution can be determined. Probably the biggest problem with original intent is that this isn't really a solution at all. The only way we could ever determine the original intent of the founders is to read their writings, but that poses the problem of how are we to interpret those writings? So we've merely pushed the problem back one step, and are now faced with the task of interpreting words that aren't even a part of the Constitution, even if we could be assured that we could get a comprehensive viewpoint. Another problem, and a large one, is that there were many different founders with many different intentions. The biggest is the debate on federalism versus nationalism. Should we have a strong central government that the states are subordinate to, or should it be a small government subordinate to the states? These and other divisions make it impossible to suggest with any rationality that there is one and only one intention in the words of the Constitution. In fact, many clauses as written came about as compromises between these different camps, nationalism versus federalism, slavery versus abolition, and so forth. Each camp had different, even diametrically opposed intentions, and they sought to get a little of both in while checking the fears of the others. Basing the interpretation on intent is made impossible by this. And finally, the founders, in particular James Madison, specifically said that they never intended for their intentions to be the guide. They knew how problematic this was. So if one cannot interpret the Constitution by original intent, what of the living text? The essence of the living text method is that the meaning of the Constitution changes with the times. Since we the people ratified the Constitution must conform to our perceptions and intentions. This is expressed by Congress in the form of informal amendments, and so Congress at any point can pass legislation that would have in the past been unconstitutional, but by passing it, they have made an informal amendment, which changes the meaning of the Constitution to allow the legislation to be legitimate. And finally, the judicial branch, and in particular the Supreme Court, can declare, in a case presented to it, that the Constitution has a certain meaning, and from that point on a precedent is set by which all future legislation and court cases must abide. Again, all of these ideas are specious, and I will now proceed to explain why. First of all, how precisely is the Constitution supposed to change with the times? In our first lecture, we discussed at length the idea of consent and where constitutional legitimacy comes from. Here we're changing this meaning based on what the people want, but who is to say what the people want? And like the founders, our views and opinions are varied and often mutually exclusive. This is even more problematic than original intent. Also, it has been pointed out by many that a document that can mean anything means nothing. If the Constitution can mean whatever people want it to mean at the time, then what is the purpose in even having a written Constitution to begin with? Couldn't you just skip the whole Constitution business and go straight to the will of the people? And do any of us really want that? Informal amendments are invalid for a number of reasons. The biggest is that the Constitution clearly spells out in Article 5 how it is to be amended, and it allows for no such process of informal amendment. Also, the amendment process was made by design to be quite difficult. They did want the meaning of the Constitution to change when necessary, but only when necessary. They absolutely did not want illegitimate clauses to be put into the Constitution. So the Constitution can only be amended with the approval of 3/4 of the states. If something really is necessary, it should be able to make it through this process. And indeed, this has happened 27 times since the Constitution was ratified. Also, there is nothing about an informal amendment that changes the text. The term amendment has a specific legal meaning. This is a written constitution, and so the process of amendment changes the text. So-called informal amendments don't do that, and so logically they cannot be said to be amendments at all. And finally, the Constitution is supposed to limit Congress and the rest of the federal government. But how can it do that if Congress can just go and change the meaning of the Constitution whenever it wants to? This idea of informal amendments is not only illogical, it is downright dangerous. The idea of judicial reinterpretation is the most popular. It says that since the Supreme Court is the ultimate arbiter of the Constitution, then whatever they say the Constitution means is what it means. However, as with Congress, the Constitution also limits the judicial branch. The Constitution is there to limit all of the federal government. That includes federal courts, even the Supreme Court. Again, how can the Constitution limit them if it can just mean whatever they want it to mean? The fact is, there is absolutely nothing in Article 3, the article covering the judiciary, that gives them anything resembling such a power. And again, Article 5 says how the Constitution can be amended, and there is no mention of the courts at all. In reality, this has led to morphing interpretations of interpretations. For example, the word unreasonable in the Fourth Amendment, when describing unreasonable searches and seizures, led to the court allowing for police to conduct a pat frisk for a weapon. This was reasonable because it allowed the officer to do his job without fear for his life. However, years later, the Supreme Court ruled that a police officer could demand an ID from someone who is not a suspect and arrest him if he refuses to comply. Their reasoning was that since demanding an ID is less invasive than a pat frisk, then if a pat frisk is reasonable, so is demanding an ID, completely forgetting the reason why the pat frisk was reasonable in the first place. Since demanding an ID has nothing to do with officer safety, it was not found to be reasonable based on the Constitution, but on their previous interpretation of it. This is obviously a huge problem. And again, this changes the meaning of the Constitution without changing the text. As with the other forms of living text, this completely negates the reason for having a written Constitution to begin with. So, if one cannot interpret the Constitution based on the original intent of the founders, and one cannot interpret it based on the current times, what's left? What is the only logical way in which the Constitution may be legitimately interpreted? Once again, we turn to the words of James Madison. Madison said the Constitution should be interpreted in, quote, the sense in which the Constitution was accepted and ratified by the nation. In that sense alone it is a legitimate Constitution. And if that be not the guide in expounding it, there can be no security for a consistent and stable exercise of its powers. Do not confuse this with original intent. What he's referring to is the original meaning of the words as they were understood at the time of ratification. This is an important concept in that the meaning of the Constitution is locked in at the time of ratification and can only be changed by the process of amendment as provided for by Article 5. Unlike original intent, this is not ambiguous. The plain text reading of the Constitution as the words were used at the time of ratification allows for clear interpretation of the meaning. Unlike living text, this is not changing, except by the amendment process. Congress cannot change it, the President cannot change it, the courts cannot change it, and so none of the restrictions on their powers are in jeopardy. As we will see in future lectures, original meaning handles even the most controversial clauses, such as the 2nd, 9th, and 10th Amendments, the Commerce Clause, and the General Welfare Clause. And it still allows for modernization. Since we're going by meaning and not intent, we can apply that meaning to our modern world without having to change it. For example, television and the Internet did not exist at the time the First Amendment was ratified, yet the meaning of the freedom of speech and the freedom of the press still applies to these new media. Only the technology and methods are different. The concept is the same. Understanding this will help us greatly in future lectures. It will also help you as you listen to politicians and pundits talk about the meaning of certain passages. Now, when you go and read through the Constitution, you have a basis for understanding the actual meaning of the words, and where any ambiguity is present, the meaning can be objectively determined with a dictionary of the time, or by reading the writings of the time, not to determine intent, but to determine how the words themselves were used and meant. Until next time, stay strong and be free.